because I'm a data-driven person, could you restate actually the number of temporary employees that are in California today?
This is
approximately
in 2010. We don't have our numbers for 2011 yet.
Right.
But in 2010, it was 920,000. Average daily employment of over 244,000.
Mm-hmm.
And over 340,000 of those temporary jobs did convert to our clients' full-time employees.
Okay. So just to follow on that, when you do these numbers, do you do an analysis of the educational attainment? You know, I mean, this is almost a little less than 1 million workers that year in 2010. And I mean, what I'm driving at is, of course, we have heard two very different pictures of, you know, of this workforce. Is there a tendency for those who have not attained, for example, a high school degree, to be those that are, you know, they remain in this sort of temporary status for 5 years? I mean, 5 years does seem like a long time. It's 60 months, slightly less than the tenure of an assembly member. But that we have a temporary employment situation as well. But what I'm driving at is, do you have data out of this almost 1 million workforce, or 920,000? Do you ever drill down to that level of information?
We do not, but in my experience with our agency, it does vary from all levels to the highly educated and those with high school diplomas. We have a requirement for our industry for high school diplomas, or at least a GED.
For her. Right, for her own. So, I mean, just I know that Ms. Torres had to leave, but I think maybe her reference to there only being a certain tier of employees is not necessarily reflective of the industry today.
Right, and the career ladder that I passed out to all you kind of shows the progression through the chain. So you have entry level, mid-level, advanced level, and then supervisor line. And it lists all the positions through there, so for your reference.
So just if, Mr. Chair, if you'll indulge my line of questioning, I wanted to ask then, since it's somewhat unusual perhaps for a temporary worker to be in place for 5 years or more, are there in your industry steps for, you know, are there training programs, career ladders? Do you provide incentives for people to take classes and so forth?
Yes, I can say that we do that. Our industry provides all of that. We have webinars. We have a number of different educational programs that we provide to our members.
Of course, that would assume that workers would have access to the Internet. You know, we still have digital divide issues. We heard that other horror story about someone being injured and not having transportation. So
sure, we have on-site events as well.
Okay.
So.
All right. Let's see. I don't know if I have any other questions. Oh, the question that I asked earlier to the other panel about what provisions do you have for workers to have regular evaluations, if at all? In other words, back to my question about it sounded like there was some willful and capricious methods of terminating. You know, are there any standards in the industry that
I can't speak to the standards in the industry. I know different employers have different methods that they use.
Do you think we should have some sort of evaluation mechanism?
We do provide courses that offer best practices that we educate our members with.
Any of the other two of you wish to answer, try to attempt that answer? In other words, for a worker who comes to testify saying she had been in a position for 5 years, but because she complained, and you should complain when you have the opportunity, that she was terminated. Is there some provision, you know, that you could comment on?
There's California law that regards to
just
that
California
in regards to maintaining a harassment-free environment.
Right.
So that's something that's required in all
true.
employee handbooks, and there is a procedure that's in place that outlines how we need to do that, and we also have supervisor training that's in play in order to educate our employees on how to tend to an issue should it come up.
Okay, so it's still reliant upon DFEH or EEOC as opposed to any internal standards for evaluating workers or providing them regular feedback about how they're doing.
Well, it's based upon that. I mean, California Staffing Professionals does have an organization along with the American Staffing Association for Certified Staffing Professional. It's a national designation, which was also adopted from the CAC, which is California Accredited Consultant for the state of California.
Thank you. Thank you, Mr. Chairman.
Mr. Allen, please.
Yeah, I'll just make some general comments before we wrap up the session. It's very obvious to me that there's always going to be a need for a contingent workforce, and that there's going to be good actors and bad actors in every industry. To me, I've always been concerned, though, is that whenever you start creating gradients between workers, it starts creating an implication that if you pay people less or if you train them less, that somehow they're not requiring the same amount of dignity and protection in the workforce. So to me, and this is the question we've been kind of dealing with today, do we need more regulations, or do we need more enforcement, more resources bent toward enforcement to get out the bad actors and to curb the abuses, or some combination of that? There was some discussion by the academics regarding the Illinois staffing law. To me, I kind of take the attitude that when you come before us, you're sincere in telling us the truth. I know that the stories we heard from the workers, I absolutely felt their sincerity and believed their stories about the abuses. So to us, what we have to kind of thresh through is, and to me, that big question of, do we need more resources put to our enforcement rather than putting on additional regulations or some combination? But I want to thank all the witnesses, both the employees and you and the academics that came today to testify. Thank you.
Yeah, well, we have one more panel, but let me just say that I really appreciate the testimony also. And I actually wish that more of the industry perspective witnesses were able to attend today. They were not. However, we will leave the record open for the retailers, other hotel representatives to communicate to the committee, because what we want to find is a solution to this. I agree with Mr. Allen that the witnesses were sincere. I have no reason to doubt your concerns, even the personal stories that you've shared before us today. That it is extreme, to have harassment, and it's unacceptable to have retaliation and threats. And many of the people that testified today say they also want dignity, and so I think that that's very important. But we also need to hear from industry to help us understand which approaches you feel will help weed out the bad actors so that we can restore issues of dignity and respect, because it's very difficult to see how you could have two employees, it's very difficult to accept two employees working in the same situation, wearing the same uniforms, doing the same job for 5 years, and one being very, very insecure about their position, with no sense of security, and being compensated, significantly differently. And so that is clearly, un-American. So we have to figure out a way to address that inequity. So I would say the record will remain open, for additional written perspectives to come forward. We appreciate your testimony today. You showed up, so we respect that. We have one more panel on the enforcement question, and so we will call the witnesses for that.
Next panel, we have Julie Sue and Ellen Wides.
Okay. Thank you. This is our last panel on the subject before any public comment. We are on schedule to end the hearing today by 1 o'clock. So please, thank you. Just introduce yourself for the record and begin.
Thank you. Good afternoon. My name is Julie Sue, and I'm the California Labor Commissioner. Mr. Tejeda already spoke very eloquently about the, among other things, the investigation that my office did on October 12th of a warehouse. So I'm not going to repeat that. I do want to talk a little bit about some of the lessons that we learned. Given the size of that warehouse, given the suspected violations, and the complexity of the relationships, as they've already been noted earlier today, I sent a team of about a dozen inspectors so we could meaningfully interview employees and the employers, and if citations were appropriate, collect the proper evidence to support them. I do want to take a moment to thank Mr. Tejeda, because without workers like him who speak out, it would be impossible for us to do our jobs. What we found in the workplace was rampant violations of Labor Code Section 226. It's the strong public policy of the state that every employee should know what he or she has earned. And this is codified in Labor Code 226, which requires that the wage statement include hours worked, if piece rate is paid, what the piece rate is based on, how many pieces were completed, and the like. And in my time as labor commissioner, I've worked with a number of employers who are trying to comply with 226 to help them to do so. But in this particular case, the wage statements did not have anything about the hours that were worked. They did not have the number of pieces completed or the rate of pay by piece. In fact, one of the wage statements has the word piece, or P-I-E-C, and it says a rate of $1, and then it has hours, which coincidentally always correlates exactly to the amount that was actually paid. So you have the hours were sometimes 213.33 because the check was for $213.33 times the allegedly $1 of piece rate. These sorts of problems are precisely why the labor code is strong on what information needs to be given to workers so that they know what they've earned, how much they should have been paid, and whether those pay requirements are being met. In addition, we did issue citations, as Mr. Tejeda said, and in addition, we found that workers sometimes came to work and signed a blank timesheet, which the workers never knew ultimately what hours were put onto the timesheet. And we issued their notice to discontinue also so that they would correct their violations. But in terms of challenges, I want to note that several months before this investigation, a deputy labor commissioner went to a warehouse to try to inspect. And the warehouse representative told him that he could not speak to the employees because the warehouse was not authorized to permit it, since they were not the warehouse's employees. In fact, what the warehouse representative said is that I have no authority to allow you to do this, despite the statutory recognition of the labor commissioner's authority to investigate in different workplaces. So what the deputy labor commissioner was told was, you have to go to the office of the staffing agency and we will send workers there whom you can interview, which obviously violates the very purpose of the access to workplaces that is given to my office. Another one of our important statutory obligations is to investigate claims of retaliation and to make the protections against retaliation real for workers. That is embodied in Labor Code 98.6 and 98.7. There's also a Labor Code section 1102.5, which says that an employer may not retaliate against an employee for disclosing information to a government or law enforcement agency where the employee has reasonable cause to believe that the information discloses a violation of state or federal statute or a violation or noncompliance with state or federal rule or regulation. Unlawful retaliation against people who provide evidence to the government is a serious problem, and you've heard about it here today. I've taken meaningful steps to deal with this. As already described, warehouse workers have had their hours cut, higher paying positions stripped, and they have been told not to come to work in punishment for speaking out. My office investigates these claims, but I have reprioritized the retaliation that occurs following government enforcement. Namely, if we do an investigation and retaliation is alleged immediately thereafter, we move on that right away. If a worker files a wage claim with my office and retaliation is alleged after that, we move on that right away. And if DOSH does an investigation for health and safety violations, then if alleged retaliation occurs, we respond right away. Obviously, this is a priority for all of us in government, to protect the workers that cooperate with us in our enforcement efforts. If we cannot protect them, it undermines their trust in government and pushes these types of violations further underground. Our efforts have to avoid putting workers in harm's way for assisting us. In one of the investigations that we did, and this goes to the challenges of a subcontracted industry, the rationale for getting rid of the workers was a contractual one, that it's a contractual decision not to use that particular agency anymore. So the contractual relationships make it easier to deflect attention from actual retaliation. In addition, what can happen is that when a warehouse breaks the contract with a staffing agency, one of the justifications is they say, well, we've now eliminated all of the workers from that staffing agency, so it can't possibly be retaliation against those particular workers who spoke out. And here it's just important to acknowledge that the goal of retaliation is not just to silence the workers, but to send a message. Employers benefit as much or more from the chilling effect of unchallenged retaliation as they do from the removal of certain workers from the workplace who are labeled troublemakers for their courage. Warehouse workers experience, as they've described, an obfuscation of the traditional employer-employee relationship. And what was found in the Schneider warehouse that we investigated is the warehouse presents its relationship with the entities that supply their labor as purely contractual, yet the contract allows them to dictate nearly every material term of employment. This was the conclusion of the federal court that reviewed the allegations that the workers brought. And so the other argument that's often made is that because the staffing agency is charged with ensuring compliance with the labor code, the warehouses or the entities that hire them have no responsibility to be. And so the various layers of subcontracting create problems for the allocation of responsibility. Some businesses use them to cut costs, as was already described today, and the downward pressure on prices often leads to labor abuse. The legislature has acknowledged this problem by enacting Labor Code 2810. Labor Code 2810 prohibits entities who contract for labor from knowingly paying contract prices that are insufficient to cover labor costs. But it only applies in 5 industries, and warehouse is not one of them. But I raise Labor Code 2810 because it is a legislative recognition of this phenomenon of labor contracting leading to labor abuse. In sum, the challenges to subcontracting from an enforcement perspective are that the layers of subcontracting can be used to deter investigations. The existing challenge of conducting meaningful investigations and speaking to workers at their workplace is magnified when a business can avoid our entry by stating that they cannot be the ones to grant the right to investigate, even though the work is occurring under their noses. For unscrupulous employers, this is the classic case of the fox guarding the chicken coop, or the hen house. I'm sorry, I'm very bad at idioms. But the confusion that's created is bad for the employers who are playing by the rules as well. For the ones who do employ their workers directly, the ones who want to comply, the confusion as to allocation of responsibility isn't good for anybody. And the second point about retaliation is that when workers are increasingly treated basically like temporary workers, like day laborers who work for 4, 5, even 10 or 12 years and are still considered temporary help, it is destabilizing for the workforce, and the cuts to the hours or the days or even weeks of work that workers were doing before they reported can often be justified under the guise of, well, we just didn't need you that day. And this makes it very difficult to prove retaliatory action. My office will be a strong presence in the industries where violations like these occur. We have stated clearly our priority on attacking problems in the underground and focusing our resources on uncovering sophisticated schemes to cover up abuse. Employers who play by the rules should know that the state is on their side. They too need and deserve our protection. And the workers of the state, like the warehouse workers who have to struggle so hard just to get by, we need to let them know that in California, there is a floor under which no one should be forced to live and work, and we will fight to defend it and make it real.
Thank you very much. Appreciate your testimony a great deal, and we also appreciate the work that you have been doing to protect the rights of these workers who showed a lot of courage today to come forward, and we certainly are on the same page with reference to retaliation. Unacceptable, but thank you for your comments. Please introduce your. Are you going to also make a presentation?
Sure.
Okay,
I'm Ellen.
Mm-hmm.
Good afternoon. I'm Ellen Whitus, and I'm Chief of the Division of Occupational Health and Safety. And I have the misfortune of being last, and so I will really try to be brief and also not to repeat much of the very, very rich testimony that's come before us, as well as from my sister regulator. I want to just begin by saying that since we're looking at the warehouse industry as an example of subcontracted industries and subcontracted economy, the warehouse industry is of concern to Cal OSHA particularly. It's consistently among the state's highest hazard industries because of the high incidence of injuries and illnesses, lost work time. And we've heard from the workers' testimony particularly rich examples of the problems of the complexity of work, fast-moving vehicles, the increasing speed of production demands that do increase hazards. And your question about the effects, I wish we knew specifically and we could indicate that. However, we see very, very high rates of injury among permanent employees in the warehouse industry as well as temporary. Some of the most serious hazards include forklifts, falls from heights, being crushed by falling loads and pallets, repetitive motion injuries, extreme both heat and cold in some warehouses, extreme problems of machine guarding, slip and falls, chemical exposures, even confined space hazards, moving trucks. People in one of the warehouses we investigated described it felt like being on Highway 405 with trucks moving and people being just frankly afraid to move. And as Linda Delp also indicated, these are the kind of hazards that particularly call out for serious and comprehensive injury and illness prevention programs, emergency response plans, hazard communication, and provision of personal protective equipment for the many, many serious hazards. We have found very significant health and safety hazards to workers both who work permanently in this industry as well as workers who are, as we've heard in this testimony, who are providing labor, who are substituting for permanent employees in the ever-expanding temporary subcontracted workforce. And as you know, we respond to complaints, injuries in the case of warehouses, and also we do programmed inspections in this industry because of its high hazard, inherent high hazard nature. And over the past 5 years, we've issued approximately 2 million in proposed penalties and over 1,000 citations. So just to give you an indication of the severity of this industry. I want to report today on our most recent case, which really points out the complexity and challenge of enforcing really where we have dual employers. We have a primary employer, temporary agency, in this case, tri-state staffing agency, which provided workers for National Distribution Center, which is also referred to as NFI. Workers have referred to that, and I will as well. Workers came to us in August taking the courageous step of coming forth and filing complaints with Cal OSHA, knowing that their jobs might be on the line. And as you've heard, they have been on the line since then. They alleged numerous health and safety violations. As a result, I sent in 2 investigators who spent months walking the miles and miles of 4 warehouses owned by NFI. And interestingly, one of those warehouses had permanent employees only, and the other 3 all had predominantly employees of the staffing agency. So in this case, it's really, I think it's interesting for your benefit. It's not a question necessarily of really permatemp employees working next to permanent employees. It's really there has been almost a total substitution of labor by temporary subcontracted workers. We did a total of 9 investigations of all the safety and health hazards. We also investigated the heat stroke case that was referred to that was really not reported properly to Cal OSHA. And as a result of our long and very comprehensive investigation, because we really were looking at the responsibilities of both employers, which really made, as I'll explain, our investigation complicated, we issued 60 citations to both employers, Tri-State Staffing and NFI, many of those serious violations. We considered both as a result of our exhaustive investigation, both of them dual employers, and at least for Cal OSHA, under the Labor Code, especially Labor Code Section 6400, 6401, 6401.7, 6204 through 6204, we can exercise authority, and there is a statutory authority for all employers to protect the health and safety of workers, to furnish appropriate protective equipment and clothing when necessary, to provide adequate injury and illness prevention programs, and others. Our enforcement policy, in this case and others, is really predicated for dual employers on precedents set by the OSHA Appeals Board and Courts of Appeal decisions. We have numerous statutory confirmations of ours, in all cases affirming our authority to cite both, subject to our ability to find control and supervision by each employer. And we found that clearly both the primary employer here, the staffing agency, as well as the secondary employer, the warehouse itself, exercise control and supervision. For the warehouse, they had full knowledge, they had control and supervision over all of the overall operations. They dictated production levels, as we've heard, and in the speed of production, the quantity, the machinery used, and such. Tri-State Staffing, interestingly, had both a management and health and safety person on the warehouse floor, indicating its supervision and control, directing and even supervising employees, getting reports of worker injuries, maintaining the log of worker injuries, the log 300. So both, in this case, exercised supervision and control. We are continuing to investigate the very real and serious complaints of retaliation, working with the workers and working with the Labor Commissioner. We are aware that workers who filed complaints with us have since, as you've heard, not been asked back for work or had their work hours severely reduced. We've also heard testimony from workers that they have been reluctant to file any reports of work injuries and illnesses for fear of not being asked back to work, not being allowed to continue to work. Those are all violative conditions, and we will continue to work with the Labor Commissioner to get to the root of it. We are also saddened and deeply upset by reports we've had from the workers of threats to bring in ICE in these workplaces, in these warehouses. And I've had reason to be in contact with ICE's Worksite Enforcement Division in Washington and also in the Inland Empire to ensure that ICE does not become involved in legitimate labor disputes when workers have exercised their rights to a healthy and safe workplace. I want to just conclude with the challenges that we find in dealing with these complicated subcontracting relationships and how that affects our enforcement. As Julie has described, these dual employer on-site relationships really make our investigations very, very complicated. We have to prove in depth who actually has control and supervision over every part of the operation, what are specific functions each employer has, and the burden is on Cal OSHA to really apportion responsibility between those employers, between primary and secondary employers, burden to both apportion the responsibility as well as the penalties. And it really, this kind of complicated subcontracting often blurs responsibilities, so adds to the difficulty of each case investigation to do it properly. It's easy to just hold one employer liable and be finished with it, to meet expectations of completing numbers of cases as we're expected to do by Fed OSHA. Under my administration, we're going to do more comprehensive inspections, even if that results in very long, very exhaustive, comprehensive inspections, because in cases like these, we believe that the Labor Code gives us authority over both employers, and if we do not go and hold both responsible, we are really not addressing the serious health and safety risks to workers. The danger, of course, of having to cite both is that each employer can point the fingers at each other and in an attempt to evade responsibility altogether for compliance. I was struck by a comment by Ms. Raboff that the client of the staffing agency is responsible for OSHA compliance. Well, under the Labor Code, both are. Both the controlling employer and the staffing agency. These dual employer relationships also really could be, I think, very confusing on at least three levels. They're confusing for us, they're confusing for employers, and they're confusing for employees. For employers, it is confusing what is actually their responsibility. Do they have to provide personal protective equipment, training, compliance, and who is doing what actually on the job site? For employees, it's perhaps confusing who is actually responsible for providing personal protective equipment. In the warehouses, for example, steel-toed shoes, which are a must given the likelihood and the danger of falling heavy objects. Workers had to pay for their own protective equipment, provide it and pay for it. Who provides training on the hazards, as the workers pointed out? Who is responsible for correcting those hazards? Who is responsible for giving them directions? Who investigates illnesses and injuries that are reported? Who should they report an imminent hazard? And if they believe they should refuse dangerous work? And for Cal OSHA, as I've mentioned, these are difficult proof problems to determine liability and the proportion of liability. And how we can properly ensure compliance with Labor Code 6400 et cetera. As I mentioned, in this case, we found the facts supported both. But I want to just underline the fact that these cases are all very case-specific, fact-specific. We might not always find the facts as we found these. And the kind of legal and technical analysis to sustain citations, and both of these employers have already appealed our citations. So in order to sustain them, to really do justice to health and safety, we have to really maintain that standard of proof. So I just want to conclude also indicating that our agency will do everything within our power to investigate this aspect of the subcontracted economy in the warehouses and others. But in the warehouses, we'll continue to respond to complaints, to continue programmed inspections that don't necessarily put the workers at risk for coming forward, as they have courageously here, for following up with the labor commissioner to make sure that when workers do file complaints with us on specific issues of health and safety violations, we cooperate and assist the labor commissioner in dealing with retaliation complaints, and doing all we can through education of the warehouse industry, both the staffing and the warehouses themselves, of health and safety responsibilities through our consultation service, but also ensuring that we will cite seriously when we find the kind of violations that we did in this case. Thank you.
Well, thank you very much, and I have to agree with you. I don't see any appropriate role for ICE to play in the situations that we're discussing here. They shouldn't be used to intimidate or threaten the workforce. That's very important. I also think that we all can agree that any intimidation of the workforce, any threats of retaliation, any actual retaliation cannot be accepted. The committee would welcome if there's some enhancement of the labor code that you feel is not clear in terms of access for investigators to have access to warehouses. We would like to know where you believe the labor code should be adjusted to clarify that you do have a legal right and that there is some accountability in the situation. We are trying to make sure that there is restored a system of fairness. We believe there are industry representatives that are also interested in making sure it's a level playing field, and those that are bad actors should not define their existence. I got that, and that's clear by the testimony that we received today. And so the record will remain open for any suggestions about the labor code enhancements that may help this situation. We appreciate the work, and I think if there's we have Ms. Yamada.
Very quickly, I know you probably want to allow for some comment as well. To Julie Sue, I did want to reference, your remark about the fox in the chicken house. I think Proposition 2, the chickens have been freed. So maybe we can do, as much for some of our workers. I want to also thank you for your strong position on enforcement. I spent about 10 years of my life working as a federal investigator and also for the county and the city in Southern California. So I'm very familiar with the need for access for investigators, to be able to have free, reign, essentially, to ensure that we get the facts. I wanted to ask Ms. Whitus a little bit about, and I think the chairman has already referenced this, but the ambiguity in the law right now, is that something that you see could be a service to strengthening, who is responsible? And I want to, for fines and so forth. Is it right now a proportionate assignment for fines? Or is it, if both parties are equally at fault, could we level a double fine? Is it currently a double fine authority?
Right. In this case, we have issued equal penalties to each employer.
Okay, so that's already permitted.
Of
Okay.
course, the employers can then appeal that
Right.
and dispute the proportionality. That's their right. And we have to then sustain the burden of proof that their degree of control and supervision merited the degree of culpability
Right.
and penalty.
And just to follow up on that very quickly, about if you could say the average case processing time from the beginning of the complaint to the adjudication and through the appeals, are we talking 5 to 10 years, 5 years, 3 years? Well, and I know it's a case-by-case basis, but depending on how big their lawyers are and so forth and so on, and are there other settlements that are ever achieved?
It's a great question. The investigation itself, there were 9 investigations, and these are miles-long warehouses where we did wall-to-walls of everything and interviewed many, many, many workers. That took over 5 months. But then the cases are now appealed. I'm not sure when the OSHA Appeals Board will be able to calendar them. Abatement is stayed pending
Right,
these
exactly.
appeals.
I think we heard that at another hearing. Abatement is stayed until the outcome
And that
is
means
determined.
that a number of these very serious hazards remain, which is of grave concern to us. And that could take years. We hope that with the new augmentation of the appeals boards, ALJs, we'll see faster, turnaround.
Case processing
But
time.
the appeals process can take years, and the workers continue to be at risk.
Mr. Chairman, could I add to respond to the Assembly member's question? In the cases that we've had, we've only issued citations against the staffing agency, and it's in part in highlighting Ms. Whites's testimony because to prove that the warehouse itself is a joint employer or exercises enough control is an extremely fact-intensive and difficult analysis that needs to be done, and so it requires, again, from the enforcement perspective, it's very, very resource intensive. It's not to say the facts don't exist, it's that they're extremely resource intensive to do. And so our investigation was opened about 4 months ago, and the ongoing investigation of who else is responsible has still not been concluded.
And these are civil penalties only. It's not criminal penalty yet.
We have the
Thank you.
authority. We have the authority to refer cases
To do criminal penalties
in
as well.
appropriate cases.
Thank you. Thank you, Mr. Chairman.
Mr. Allen, anything?
Yeah, if it could be possible, if it could be supplied to the committee and to the members of the committee, I would like to know the amount of resources you have for both enforcement, both for the Labor Commissioner and Cal OSHA, by region and by industry. I would, and the average caseload. And I had another question too. Is that regarding these rules of apportionment, were these done through case law or were they done statutorily? And are there ways that they could be clarified or simplified?
The proportionality,
Yes.
I think, is how we interpret appeals board cases and court of appeals cases. For example, the Sully case, numerous appeals board decisions. Labor Code 6400 also describes the different sorts of employers, the exposing, the controlling, people who are responsible for correcting, and so forth. But then, again, it's very fact-specific for us to prove who did have those responsibilities. And again, we may find, as we did in this case, that both really equally did. So I think it's really a matter of appellate decision. I don't think, given the universe of different facts we'd find, we could do that by statute.
Yeah.
I think that's the challenge of fair enforcement, to do these exhaustive investigations and analyses.
Fair enough. I have another question regarding, for both agencies, caseload standards for the folks who are out doing the enforcement would be helpful. And also, basically, what is the expectation? I heard you mention that the Fed OSHA and there may be, Department of Labor for the federal government have certain expectations regarding processing of cases and time. And I think that would be all interesting to kind of look at the totality of this to try to figure out what's going on, just not only in the warehouse industry, but throughout California. Thank you.
And I would say, as a member of the Budget Committee, I think that the resources of each agency is important, because a small tweak here or there may give you more resources to help with more of the more complicated investigations when you're looking at questions of supervision and control. So we'll remain mindful of that. Thank you.
May I ask just one last question? Back to the issue of the staying of the order until all this is adjudicated. Are there ever any? So there is no provision in the law currently for the issuance of any kind of an emergency order, or there is. If it's just so egregious.
If we are aware of an imminent hazard, we can come in and issue an order prohibiting use or an order to take special action.
Thank you.
Well, thank you. Thank you so much for your testimony. We appreciate it. We did not get any, no one signed up for public comment, but there is some that are interested, I see. So we'll have you come forward for your public comment. Yes. Was there another? Yes, please come forward. Okay, yes, please.
Thank you very much, Mr. Chair and members. Angie Way on behalf of the California Labor Federation. We appreciate this opportunity to testify before the committee today and for the committee's willingness to do the hard work of investigating and peeling back the onion on the issue of subcontracted and contingent work. I just pulled out my iPhone because I think most recently many of us have been reading with some horror Apple and their policies or lack thereof with the subcontractors in China, namely Foxconn, and how many of us have probably read the stories. Chinese workers live, in the company dorms, and when Apple makes a decision, Steve Jobs specifically, rest in peace, decided that he didn't want a plastic cover for his iPhone, that they didn't want plastic, they wanted glass. They roused all the workers up in the middle of the night, and within 3 hours were able to flip the iPhone's product into a glass cover at the call of Apple. And so that's the question here. Who is ultimately responsible for making these decisions that affect the labor issues all the way down the line? And I've been watching with horror because I do have one of these things, and Apple is the company that we're all growing to hate to love, I think, or love to hate soon. And it's horrifying, the working conditions that those subcontracted workers are, they're committing mass suicides, jumping off the factory roofs because of the working conditions imposed by these subcontractors. We're watching with horror because there's not much we can do with the labor laws in China, and many of us are asking for, morally, what is Apple's responsibility for these subcontracted workers? Well, guess what? This isn't just happening in China. This is happening down the I-5 corridor, and this is happening along the corridor from the LA Long Beach port all the way across to the Inland Empire into the warehouse industry. This type of subcontracted denigration of work is happening in our own state. And we can do something, not just morally, but legally here in California and here in the United States. 3 very brief points that I'd like to make. The first is that we thought that some industries would never leave California, that the work that they do could not leave. Hospitality industry, warehousing and distribution. The sergeant very kindly passed out these 2 flyers that show that even the hospitality industry is subcontracting out their work, denigrating the value that workers provide to the company's profits every single day through the toil of their labor. And you'll see from these flyers, the hospital staffing agency sees workers as being able to be purchased out of a vending machine. You can order from the vending machine a cleaner, a banquet server, the maintenance person, the building engineer. Here, you can order us, the workers, out of the crime lineup. It's not that these jobs and these industries are leaving California. These good standards, good jobs, the middle class is leaving California through the denigration of our work, where we're treated like and seen as commodities like this. So this isn't about industries leaving California. This is about good middle-class jobs leaving California. And we are at a crossroads now where we can actually do something about it. The second point I'd like to make is that this is about the work of the future. Many have heard about Project X coming to the Central Valley, to Patterson, California. We think that that's going to be the big Amazon distribution center. Amazon works on a permanent model throughout the United States, where big warehouses, the same deal, permanent temporary workers who are paid on piece rate, where the incentives there are to work harder, work faster, work for less. And in the Central Valley, we actually have warehouses in which the workers are direct employees, not subcontracted, not temped out, and union represented. We cannot let this model of temporary work in the warehouse industries travel up the state and enter the Central Valley. We have to make sure that that work maintains good work and hopefully good union work. And finally, I'd like to say that we could not, I would argue fiercely that we could not get any more committed appointees to an administration, to the enforcement of our state's labor laws, and to the special consideration they pay to the most vulnerable among us, immigrant workers, in my opinion. That the representatives that we have from the agency here throughout the labor agency are committed to enforcing our rights for immigrant and vulnerable workers. No matter how committed they are, given the reality that we face with our limited labor law enforcement budget resources and the budget across the state, they can only do so much. So we have to find creative and unique ways to make sure that the working conditions of China do not soon become the working conditions of California, and that we all accept a new normal for how workers are treated in our state. We very much thank you for this opportunity to provide public comment. We look forward to a vigorous year in working with each and every member of the Labor Committee on both sides of the aisles to slay this issue. Thank you very much.
Thank you. Yes, sir.
My name is Nathan Austin. I'm an attorney with the law firm Jackson Lewis, and TS Staffing Corp, doing business as Tri-State Staffing, referenced by Ms. Whitus, is a client of Jackson Lewis. I just wanted to clarify one point for the record. Ms. Medina testified that earlier this morning that about her experiences with NFI Industries. Wanted to clarify that she is an employee of TSI and not NFI Industries. That's
Well, thank you very much.
Thank you.
Appreciate it. Ma'am.
Hi, thank you. My name is Jamise Myers, and I'm a researcher at the East Bay Alliance for a Sustainable Economy, eBase, and I came today from Oakland, California, where eBase is located. eBase is leading the Revive Oakland Coalition, which is working to ensure quality jobs on the massive redevelopment of the Oakland Army Base, which is to be transformed into a warehousing and logistics hub for the Bay Area. Revive Oakland consists of about 30 labor and community organizations and many members working to ensure that the redevelopment of the base provides quality jobs for Oaklanders first. And on behalf of eBase, I just wanted to appreciate Assemblymember Swanson for taking leadership on this really critical issue and making sure that the Army base fulfills its promises to local folks in Oakland. So just a little more commentary. The Army base is slated to provide about 2,000 to 3,000 warehousing jobs in the future. So the woman before me said that this is the work of the future, and that's certainly true in Oakland. Around the Army base, 3,000 warehousing jobs. And Revive Oakland is working to make sure that the workers have the right to organize for fair wages, a voice, and health and safety conditions free of employer retaliation that you heard about today. We want to prevent the worker injustices that you heard about from the workers in Oakland. Earlier this month, the Oakland City Council unanimously adopted a quality jobs framework for the Army base that includes labor peace, local hire, and banning the use of temp agencies. And this framework, which was unanimously passed by the City Council, will be used in negotiations with the developer of the base, Prologis. But there's still a very serious threat that this industry norm of subcontracted work could still end up on the base at Oakland, and we want to make sure that doesn't happen. Just to give you a little background on Prologis, who's the developer of the Army base redevelopment project. They are a multi-billion-dollar industrial real estate developer. They are the owner and manager of warehousing space globally, and Prologis paid their CEOs $13 million last year. Their clients include the largest retailers like Walmart, yet temp agencies operate in Prologis warehouses around the globe. So I am here today to express support for and the need for increased regulation and enforcement that will allow us to improve the conditions of the future warehouse workers at the Army base. And also, I hope that this hearing is the first step to make that happen. I encourage you to support the City of Oakland in their negotiations with the developer so that they can uphold this framework that the community helped to create around these job standards. And if you need any additional information about the Army Base redevelopment project, I have it here along with my card. Thank you.
Thank you very much. We don't have any other witnesses. Okay. Thank you very much, and that concludes the public testimony. The committee would like to, first of all, thank the workers who testified their perspective, the industry representatives that came forward and were very candid and forthright in their comments, and the enforcement agencies' presentation, all very meaningful and important to the work of the committee. I also want to just reemphasize the fact that the workers who testified, we will continue to do everything we can to make sure there's no retaliation against those workers that come forward before the committees of this House to testify. We want to thank everyone for their attention here. We also will be looking specifically at additional legislative remedies to address this, and we will leave the record open for more input from the workers, also from industry representatives, as to a way for us to level the playing field and to make sure that everyone is treated with dignity and respect. And I think in the long run that will help us produce and grow jobs here in our state, which is very much needed. And so this has been a very useful session that we've had, very open, very candid. And I think very substantive. So with that, this hearing stands adjourned.